So welcome to today's seminar, our storm seminar, Municipal Finance of Stormwater Projects. My name is Jeffrey Albrecht. I'm an engineer at State Water Board in the Division of Water Quality. I work in the Stormwater Planning Unit, where we manage the strategy to optimize resource management of stormwater, also known as storms or the stormwater strategy. So this is our 8th storm seminar, and we have more presentations related to stormwater management issues planned in the near future, including our upcoming Enhancing Groundwater Recharge with Stormwater on May 30th. That'll be here in our building, but unfortunately that one will not be webcast, I believe. So today we will be discussing the challenges to funding stormwater projects, including the legislative efforts, legal cases, and ballot measures that have formed the foundation for some of these constraints. We have a great speaker and a number of interested participants joining us today that I hope can participate in a vibrant discussion and dig into some of these issues. Let's see. So before I go any further, I just wanted to mention that our mission here for the Storms program is to advance the perspective that stormwater is a valuable resource. Yes, and my obligatory emergency evacuation procedures. For those of you not familiar with our building, please look around you for the nearest exit. If you hear an emergency alarm, please gather your belongings and calmly make your way out of the building and across the street to Cesar Chavez Park, where you can enjoy the beautiful day for a little bit until you get the all clear. And then, of course, come on back and join us. We'll reconvene. For those of you joining us online, you don't need to develop your own emergency evacuation plans. Restrooms are out and to the left. Please make sure all your cell phones are silenced or are on vibrate. Let's see. So today's seminar we are doing both a webcast and recording. So if you have any questions, you must wait until we have one of our microphones to you in hand so we can get a clear recording and make sure people on the webcast can hear your question. My colleagues will be circling around with those microphones. And that recording will be posted on our website later at waterboards.ca.gov/storms. Let's see. Finally, if you are joining us via webcast and have a question, we will be accepting questions at our email address here. It's storms@waterboards.ca.gov. We'll try to get through each of those questions as part of this seminar. Okay. Now for today's speaker, Michael Colantuono. He's a shareholder in Colantuono, Highsmith, and Watley, a municipal law firm with offices in Grass Valley and Pasadena. Michael is one of California's leading experts on municipal revenues and has appeared in all 6 courts of appeals in California. In addition, he has argued 5 public finance cases in California Supreme Court since 2004 and helped brief 2 others. He will argue 3 more in the coming year. Michael served on the committee that drafted the League of California Cities Proposition 218 Implementation Guide and chaired the subcommittee that drafted what became the Proposition 218 Omnibus Implementation Act of 1997. He also chaired the League Committee which drafted the Proposition 26 Implementation Guide and is now handling some of the first appeals under that measure. He chairs the committee that is working to update and merge these 2 guides. So please welcome Michael Colantuono.
Good morning. Those of you who are here in person are the guinea pigs. You actually have to ask real questions. I invite you to ask questions as I proceed through the material. Don't be shy about your questions, because if it's occurred to you, no doubt some of the folks on the line have the same question and will not be able to engage me except through emails, which we're not going to turn to until the end. So I do want to encourage you to ask questions as they occur to you, because we have time for them. I am going to try to be as objective in presenting this material as I can, but as a human being I have my biases like all of us, and I want to be frank about them. My business is representing local governments, cities, counties, and special districts, so I am an advocate for those who want to provide government services and figure out a way to pay for them. I regularly am across the V in lawsuits from taxpayer advocates and those who would prefer government be smaller and cost less. So I have a perspective. I want to be frank about it, but I'll do my best to be as even-handed in the presentation today as I can. So with that, let's get started with our slides. That's how to find me should you need to. Here's the necessary disclaimer that we're not advertising any products or services using state resources. What's the big picture about stormwater services in California in general? Cities and counties, which own and operate streets, have the authority to serve their constituents under the Constitution. They can own property, and they commonly do, and that property includes roads and streets and associated drainage facilities. Managing that property is subject to state and federal environmental laws, including most particularly the National Pollutant Discharge Elimination System, lovingly known as NPDES, occasionally as NPDES, of the Federal Clean Water Act. This has led to very expensive mandates with respect to what's affectionately known as the MS4, the Municipal Separate Stormwater Sewer System, which local governments have found very difficult to fund and have therefore been spending more money on lawyers than on engineers of late, and we haven't gone as far down the road towards addressing the environmental challenges of stormwater as advocates would like. That's the state of play, if you will. And I believe the environmental advocates and the resource agencies have come to appreciate the funding challenge, and while they're still fighting with local government in court and in various venues because they have to, are also trying to engage with them to find a funding solution because they know they're not going to achieve their environmental objective by depending on the tooth fairy. So the legal development in this area starts with a case that I lost back in the late 90s and lost again in the Court of Appeal in 2002, called Howard Jarvis Taxpayers Association versus Salinas. Salinas imposed a fee collected on the property tax roll on all property in the city that generated more storm water flow than that property would have in its natural condition. And it charged the fee based on the amount of impervious coverage on your property. So the idea behind it was, if you impose on society more storm flow than you need to, we will treat it for you and charge you. And if you don't want to pay, detain and retain, and we won't charge you. Howard Jarvis challenged this as a property-related fee under Proposition 218, which the voters added to the Constitution at Howard Jarvis's request in 1996. And as a property-related fee, it certainly had to jump through the hoops that require a mailed notice and a 45-day delay and a majority protest hearing. But the question was, did it also require voter approval? Majority vote of property owners voting by mail, or 2/3 voter approval of registered voters in a traditional election. And that turned on whether or not the word sewer in Prop 218, which exempts sewer charges from the election requirement, meant sanitary sewers and storm sewers, or only sanitary sewers. And the Court of Appeal in this case, the San Jose Court of Appeal, said it's obvious to us that the voters only had in mind sanitary sewers. That's not the most persuasive form of judicial reasoning. And we did have a statute that was unanimously adopted by the legislature, supported by Howard Jarvis, signed into law by Pete Wilson, with not a single vote cast against it in any committee or house, that defined sewer and water broadly enough that I thought I had a better case than the Court of Appeal thought I had. And this has been the law since 2002. Since Salinas, some cities have persuaded property owners to vote for property-related fees to fund water quality and flood control services. Palo Alto was one of the first to do so, and their marketing slogan, which had pictures of sun-dappled streams with kids playing in them, was "Safe, Clean Creeks for Our Community." So they were selling a quality of life, environmental safety kind of message, and what they were really accomplishing was flood control and water quality, because if you know the Palo Alto area, they have a Francisquito Creek, which does not stay in its banks because California creeks are designed to flood in the winter when we have winters. Some communities have been successful. They're primarily coastal, affluent communities. Communities that are more working class, more diverse, and more inland, and view water quality problems like swimmer's ear as a rich person's problem on the coast, have tended not to support such fees. So some examples are the Greene versus Marin County Flood Control and Water Conservation District, which is a case I handled in the California Supreme Court a few years back, involving a flood control fee in central Marin, which had had a very bad flood shortly before this fee was adopted, mostly because of development within the watershed. And the Supreme Court in that case said two interesting things. One is that the Proposition 218 Omnibus Implementation Act of 1997, that statute I told you that Pete Wilson signed, was good authority for construing the Proposition 218. So that aspect of Salinas is no longer the law. And they also said that the elections that one conducts among property owners on property-related fees are not elections within the meaning of Article 2 of our Constitution requiring an anonymous ballot, one person, one vote, etc. So a non-anonymous mailed ballot with a property ownership qualification, all those things we learned in American history have been taken out of our political culture, are just fine in this context. Others have adopted special taxes to fund water quality and flood control programs with a two-thirds vote. We don't get two-thirds voter approval very often. The people in this room and on the phone are probably familiar with Los Angeles County's rather spectacular failure to adopt one of these fees in a property owner vote. And the property owner vote itself became a substantial source of controversy. For better or worse, Howard Jarvis and Paul Gann and the movement they represent have created an expectation in California political culture that voters get to decide when government gets money. And the idea that property owners would get this decision and they'd get this funky thing in the mail that many of them would throw away because they thought it was junk mail, would decide these issues, was itself politically controversial. So one skeptical way to look at this is the Howard Jarvis Taxpayers Association created a Rube Goldberg machine for approving these revenue sources and then criticizes the inefficiency of the machine to prevent the machine from ever actually producing any revenue. I did say I had a perspective. Fees and taxes have been more successful in affluent coastal communities. Can we use utility fees to pay for stormwater quality programs? The answer is maybe. Or maybe the answer is yes to an extent. As I said, Proposition 218 exempts from its election requirement, but not its majority protest requirement, fees that government imposes for water service, sewer service, and refuse removal services. The Proposition 218 Omnibus Implementation Act defines the water services very broadly. So I won a case called Griffith versus Pajaro Valley Water Management Agency, which is a groundwater replenishment charge on all who operate wells, which is farmers as well as rural residents in the Pajaro Valley, which is the lettuce capital and perhaps to be the cannabis capital of California. And that court said that water fees could fund everything that is required to capture, transmit, treat, store, deliver water safely, reliably. It includes stranded debt for facilities you never put into service. It includes general administration and overhead. It includes planning for future service delivery. It includes compliance with regulatory burdens. Anything that is required to deliver a water service for human use, whether it's potable or irrigation or industrial, you can recover all of your costs. Our friends on the environmental side of this discussion liked my victory in Griffith and wanted to codify it. I was skeptical. I said, you know, the legislature is about producing half loaves. You go in, you engage the other stakeholders, and you get less than all of you sought. I won this whole issue. I have a published Court of Appellate decision that gave me an entire win. Why do you want to go bargain about which piece of it I get to keep? I was not persuasive, and the legislation was pursued, and what it did was it took the definition of water and added to the end of it from any source. That's all they did. And so this has been the law for a couple years now. What's the implication of those three very pregnant words? What it means is that anything that eventually produces useful water supply can be funded from a water rate. So if you're moving water molecules from a treatment plant to a groundwater basin to a well to a useful system, you can recover any of that stream of costs. Logically, that means anything you do to lawfully dispose of effluent from a sewage treatment plant, even if that's groundwater recharge, is a lawful use of a sewer fee. So now we have this possibility that we can use sewer and water fees to accomplish some part of this larger environmental agenda. To my knowledge, and I keep a close ear to the ground on these things, nobody has tried to use this authority yet. Why do you suppose that is? Well, let me speculate. Informed speculation, but speculation nonetheless. Water utility systems and sewer systems are not always operated by the same agencies. So you've got a transaction cost where you're trying to persuade one agency to surrender money and power for the benefit of another, and the history of governance around the planet shows that's not the most common outcome, at least not without external pressure. Secondly, there's perceived to be some legal risk that nobody wants to volunteer for. City managers and district managers are by trade a relatively cautious set of people. And lastly, there's perceived to be political risk. So my sense is this opening will not be used without concerted political pressure from advocates. Others may view it differently. Proposition 218 Omnibus Act does define sewer, but it does not define sewer. There's a not missing there. There's a crucial not missing. It does not define sewer, and it does not define storm sewer. But it does define drainage system and flood control, apparently for purposes of the assessment and property-related fee provisions that require voter approval. So apparently, these services were intended to be funded only with an election, not with a majority protest proceeding. Fast forward to 2010, and the Chamber of Commerce, not Howard Jarvis, bought us Prop 26. And the different authorship is important for the difference of the measure. Prop 26 amended the California Constitution to provide that all revenues to government, state and local, 218 only applies to local government, and it's only about property-related fees, assessments, and taxes, without defining taxes and without changing the definition of tax. 26 applies to state government and local government and says everything is a tax. Everything is a tax, requiring voter approval at the local level or 2/3 approval in each chamber of the legislature at the state level, unless one of 5 exceptions applies for state revenues, and the same 5 exceptions for local revenues plus 2 more. And I'm going to walk through the 7 express exemptions and give you some insight into what they are. But I want to tell you there are 2 implied exceptions that were not written into the text but are still part of the law. One is all of our voter initiatives that restrain government's ability to finance services, 218, 26, 218, 62, and a proposition to be named later, all use the word impose. So if government is not imposing the revenue measure, if there's meaningful voluntariness in the activity of the person who pays it, then 218, 26 don't apply. So what might that be? Well, that's certainly going to be things like renting a community room at the community hall in town, where you could just as easily go to a hotel and rent the meeting room there. It's going to be paying an admissions fee to use the ice skating rink when there's no compulsion to ice skate. But if we are using any force or authority, like establishing a water utility monopoly and saying you want water, you got to get it from us, those rates are imposed. Now there's always a dispute between the San Diego County Water Authority and the Metropolitan Water District, but the current dispute between those 2 agencies is about the rate that Met charges San Diego to transport water from the Imperial Valley to San Diego under the quantification settlement agreement. I represent San Diego in that case, so again, I have a perspective. We established that the transportation rate the Met set violated Prop 26 in San Francisco Superior Court, and it's soon to be argued in the Court of Appeal. But one of Met's argument is we're not imposing this on you. If you don't want to use our transportation, you don't have to pay for it. Well, our answer is, you're the only game in town. We can't get Colorado River water into San Diego in teacups or in tankers you're the only game in town, so you effectively have a monopoly and you are imposing it on us. Judge Carno in San Francisco agreed with us on that. I anticipate that the Court of Appeal will as well. We'll see. So number one, if it's not imposed, it's not subject to 26. Secondly, it has to fund the government. So we have a case called Schmier, and it's not about breakfast breads, versus the County of Los Angeles, that said the aspect of LA County's plastic bag ban ordinance, which required retailers to impose a 10-cent fee on paper bags, was not a violation of 26 because the retailer kept the money. It doesn't fund the government. So those are the two implied exceptions. What are the express exceptions? First, a fee imposed for a benefit or a privilege, like a utility connection, are not subject to 26. A fee for a service or product, like utility services, are not taxes under 26. Fees to fund the cost of regulating somebody are not taxes under 26. Fees for the use of government property are not subject to 26, and they're not limited to cost because they're meaningfully voluntary in most cases. I argued a case in the Supreme Court on that issue on the 4th of April. We should have a decision by the end of the summer. That's called Jacks versus City of Santa Barbara. And fines and penalties are not taxes, and they're not limited to cost either because there's no cost you're trying to recover with a fine or a penalty. You're trying to change behavior. Those 5 apply to the state government and to local government. These two, the two that I'm about to speak to, only apply to local government. Development fees, fees in the land use development context, permitting fees, CEQA mitigation fees, development impact fees, are not taxes under Prop 26. They are limited to cost by other principles of law. So you can't make a living off your planning department, but your planning department can cover its costs. And then assessments and property-related fees, assessments on real property, and property-related fees that are governed by Prop 218 rather, are exempt from 26. So that's the 26 world. Every fee that government imposes must have some source of authority, because 26, 218, and 13 all say nothing in this measure creates any authority to tax or impose a fee or raise revenue that you don't already have. These are hurdles between you and your fiscal authority, but if you don't have any fiscal authority, we're not creating any for you. So you have to start your analysis somewhere else, which is where does the agency that wants to raise money get authority to impose a fee? For many local governments, typically cities and counties, this comes from the Constitution. The UC Regents, the PUC also have constitutional authority. Most special districts, every special district essentially, needs to identify a statute that gives it authority. And then local ordinances, which reflect either statutory authority or constitutional authority, can be the source of authority for a fee. So you sometimes get city managers or finance directors who got their training outside of California, who will come to California, find this unfunded mandate, and say, oh, let's just create an enterprise fund and impose a fee. And my response is, you can do that in Arizona and in Iowa, but you cannot do that in California. You sure you wanted this job? Okay, Prop 218 is a subject unto itself. I could speak for 2 hours on it and probably not bore you for most of that time. But I don't want to spend 2 hours on it, so I'm going to give you Prop 218 in a teeny tiny nutshell. You have to prepare a justification for your fee so you can demonstrate that it doesn't exceed the cost of service. You have to give mailed notice to everyone who's going to pay that fee and wait 45 days before having a majority protest hearing. At that majority protest hearing, you accept written protests from anybody who pays the fee, property owners and tenants. And if those protests add up to 50% plus 1 of the properties that you serve, you cannot impose the fee. This rarely happens. We don't get majority participation in public life in America, and we certainly don't get it within 45 days in writing. So the only successful majority protests we have seen have been in very small agencies with very homogeneous and motivated property owners. So for example, Nevada County has a sewer district with 84 customers. For some reason, they built their package treatment plant at the base of a talus wedge from the mining era, and the talus wedge did what talus wedges do and collapsed and knocked the plant off its foundation, and the county proposed to charge those 84 homeowners $4,000 a year for sewer service. Those folks were able to do a majority protest. But absent unusual facts like that, you don't see majority protests. But that does not mean they aren't significant. If a typical turnout in a city council election is 20-25% of voters, and it is, that may change now that the legislature's forced us all to move to the same date as the state election, but still, if you get 20% of your property owners unhappy at a meeting, if the peasants show up at the meeting with sharp pitchforks and hot torches, the political process is going to respond. So even though the majority protest doesn't stop fees legally, it makes a big difference politically. In the absence of a majority protest, you can impose the fee. If the fee is not for water, sewer, and trash, you also, after going through this painful process in which you're accused of genocide against old people via high water rates, you still need an election for anything but water, sewer, and trash, and that election is either 50% of property owners voting by mail or 2/3 of registered voters voting in a traditional election. You don't have to go through this process more often than every 5 years if you're willing to live with a CPI adjustment in between, but at the end of the 5 years, you have to flatline your fee or discipline yourself to go through the process one more time. Prop 26 in a nutshell. Again, this topic could take an hour. We don't have enough law on it yet for it to take 2, but it in a very small nutshell. It has no procedural requirements. The process for adopting a fee subject to 26 is given by your authority for the fee. And there's typically some sort of a noticed hearing process, but not always. And you have to qualify for one of the 7 exceptions, and they all have their own requirements. The primary requirement is that they're limited to the cost of service, except for fees for the use of government property and fines and penalties. The one that's most likely going to help us in the stormwater context is the fee for regulatory services, where we're regulating folks who generate effluent, which becomes an environmental burden, or a service fee. We're providing you flood control services and water flow management services. It's going to be one or the other. Both of those are limited to cost, and all of the exceptions under Prop 26 require the government to prove they've allocated costs among those who bear those costs in a fair or reasonable relationship. I love that lawyerism. It's either fair or reasonable, doesn't have to be both. To the payer's burdens on or benefits from government regulation. This is a less demanding test than Prop 218, which requires fees to be proportionate to the cost of serving each parcel. How much less demanding 26 is than 218 is, we're about to learn in some of the cases pending in the courts. So in light of these 2 little nutshells of complicated law, what's my bottom line advice to local governments that are looking for quarters under seat cushions? If you're going to make a rate, use a rate-making consultant. There are some agencies that do rate-making in such a sustained way that they're sufficiently sophisticated that they have staff resources to do rate making. SMUD is a good example. Most of the larger power utilities do rate making all the time, and they have professional econometric staffs who do rates. Most of us should not do this at home. We should hire a consultant because you're going to need a report that I can take to court and justify your fee with, and you don't have anybody on your staff who's in the business of writing those reports. Secondly, have the cost of service analysis prepared by your rate making consultant, reviewed by an attorney. That means when you do your rate and scope for services with the consultant, put time in their budget, in their schedule, and money in their budget to talk to me and listen to what I have to say. Imagine what happens when the COSA comes out the day before the council hearing. I go through it and have 10 pages of comments to discover that A, they're out of time, and B, the consultant has no scope to spend any money to deal with my comments. How likely is it that the client's going to be able to respond to my advice? Not very likely at all. Allow for the possibility that the legislative body will reject the consultant's recommendation. Historically, rate-making reports tended to read like scripture. There is one true path towards rate-making, and it is revealed here on golden plates and do exactly what I've said. We did that sometimes to control the board, but often to protect the board from the political process by allowing them to represent to the community that we have no choice. That's not a good idea because it's not true. Rate making is discretionary legislative activity. There's more than one way to spread your costs. You're making choices. So I recommend the consultants acknowledge the fact that we're making choices and that if the legislative body makes different choices, that will produce different rates. Secondly, don't let the board respond to the peasants with their sharp pitchforks and hot torches by just changing the numbers in the board meeting and doing something else. Palmdale Water District is a case in which they've got a fairly substantial increase in water rates. They have the hearing. Lots of registered voters show up and say, I'm not voting for you again if you adopt these. And so the board did what boards do, and they moved a whole lot of money off of single-family residential class, red voters, onto institutional class, meaning the hospital district, the city, and the community college district, red non-voters, and said, voila, we've got a solution. Well, the problem is there's no match between the rates and the record which purports to justify them, and unsurprisingly, the city sued and the water district lost. So if the board doesn't want to walk the plank that you've marched out for them, let them go somewhere else, but don't let them act that night. Continue the hearing, go redo your rate-making justification, and then adopt it on the basis of a report that sustains what they want to do. That presumes what they want to do can be rationalized under any system, but most of the time it can. The other thing I advise folks who are doing rate making is make a good record to support your rates. What's a good record? A good record includes in writing or in oral preserved, can be transcribed and made a writing, all the evidence you need to sustain what you did, what you were trying to achieve, how you achieved it, and what the logical link between those two things is. It also has the evidence you need to rebut criticism in your record that your opponents put in there. That's a good record. Covers your bases, both offense and defense. Don't adopt fees not supported by the records, my Palmdale hypo. Consider validation. Validation is a particular kind of lawsuit by which you sue the world by publishing a notice in the paper, and if anybody in the world shows up, you litigate with them whether your fee is valid. If the world ignores you, as it commonly does, you prove up your default and you get a judgment, and that makes your fee impervious, no pun intended, to legal challenge thereafter. This is not always necessary, but it makes the folks who are going to buy your debt more eager to buy it and less likely to put credit risk into the price of debt. So it's something to think about. So let's focus on stormwater recapture. We have a bill that the speaker got through before he was the speaker, AB 2403. This is the from any source legislation I told you about. It was chaptered in June of 14, and as I mentioned earlier, I don't know that anybody's relied on it yet. Senator Hertzberg, the intrepid Senator Hertzberg, is carrying SB 231. It is pending third reading in the Senate, and it would amend the Prop 218 Omnibus Implementation Act of 1997 to define sewer. And it would define it in a way, by lifting a definition out of the Health and Safety Code, that will include storm sewers as well as sanitary sewers. And in the preamble, the legislation is frank that the legislature is trying to overrule Salinas. That means an agency which relies on this can count on getting sued, they can count on losing in the trial court, and they may get a court of appeal to say that Salinas is no longer the law. So this is the beginning of a chess game that has many moves ahead, and it has to get out of the legislature, and it has to get this governor's signature, and I'm not sure we're taking bets on all of those. As of 4/6, I think I checked yesterday, it's pending third reading in the Senate. It is supported by municipal and environmental groups for the reasons we've been talking about all morning. It's opposed by some cities, largely inland cities, and by the Howard Jarvis Taxpayers Association. Crawley versus Alameda County Waste Management Authority is a Court of Appeal decision that came down in 2015. In this case, there's a joint powers authority of Alameda County and most of the major cities within it that jointly operate the refuse collection and handling system. And that JPA imposed a fee on the property tax roll to fund the cost of a household hazardous waste management program by which you can take your car batteries and your expired prescriptions and your photo lab chemicals, back when we actually handled film, to a collection point, and that will be kept out of the landfill and therefore out of our groundwater. A non-lawyer suing with zeal but not legal skill said this is a property-related fee subject to Prop 218 and it's illegal. And the Court of Appeal said it is a property-related fee, even though no services are being delivered directly to the property. You have to go to the transfer station to get rid of your household hazardous waste. But it's on the property tax bill, so it is a property-related fee. But it is a refuse fee, because even though there's no refuse definition in Prop 218 or the Omnibus Act, there's this Health and Safety Code section that's in part of the Integrated Waste Management Act providing a definition of refuse, and this is that. I mention this because that judicial process of looking to other bodies of law to find definitions that are sensible in the Prop 218 world is justification for what Senator Hertzberg's trying to do under SB 231. He's doing legislatively what Crawley did judicially. We'll see whether the folks with black dresses and wooden hammers agree that he has the right to do so. So here's a slide that says what I just said. SB 231 is akin to Crawley. Defines sewer services drawing on an existing statutory definition. It does so broadly to include both storm and sanitary sewers. It disagrees with Salinas and is going to require a published appellate decision to prevail. Query whether somebody wants to go bell the cat. As I get towards the end of my presentation and you guys start thinking of questions, I want to tell you about some pending cases that are going to further develop the law. Jax versus Santa Barbara is the case I mentioned to you earlier, in which I'm defending Santa Barbara's charter city franchise fee on Southern California Edison, which allows Edison to use the city rights-of-way in delivering electricity. Under a rule of the PUC, because Santa Barbara's fee is higher than the 1% fee that general law cities and counties are limited to, it has to appear as a separate line on the power bills of customers in Santa Barbara. Economically, that franchise fee functions like a utility user's tax. It's paid by the user as a percentage of power consumed, and only if they consume power. So a hotel owner there sued saying, this is a tax under Prop 218 and requires voter approval. A very sharp judge, Judge Anderley in Santa Barbara, said, no, it's not subject to 218. It is subject to 26, and 26 isn't retroactive. The Court of Appeal, in a decision I didn't find very well reasoned, said, yeah, this is a tax because it's the economic equivalent of a tax, not recognizing that that unsettles a whole lot of law. I imagine most people in this room work for government, and you're probably aware that when you buy things for your government, you pay sales taxes. Why would that be? Governments don't pay taxes. The sales tax is legally incident on the seller. If you look at the Bradley-Burns sales tax statute, it makes the seller liable for the tax. They're economically incident on buyers because sellers have the economic power to insist that you pay the tax, except when they don't, like on sales tax holidays at the mattress store. So we've always distinguished legal incidents and economic incidents, and I think the Court of Appeal confused the two in an unhelpful way in Jax. I had a very interesting dialogue with the Supreme Court on the 4th of April. I'm cautiously optimistic for my client. We'll have a decision by the end of summer. Why do you care? You care because it is the first Prop 26 case to go to the Supreme Court. Prop 62 case, 26, yes. It's not technically a 26 case because it arose before 26 took effect, but 26 is in the atmosphere of the case, and we may get some guidance on 26. We'll certainly get some guidance on 218. And that question of economic incidents and legal incidents, although your eyes glaze over as I explain it, and it seems really boring and academic, is vital in this way. If economic incidence matters, then anybody who can claim to ultimately pay a fee has legal standing to sue to challenge it. And that means universal standing to challenge our revenue measures, which means I make a lot of money defending fees and you don't get your money in your program until I get the litigation over, which could take years. So this exposure to litigation is really the big issue lurking beneath the surface of Jax. And we'll have a decision by the end of summer. Ventura versus United Water Conservation District. I sued United Water on behalf of the city of Ventura. United Water operates under the Water Conservation District law, as do 15 other agencies around California, notably not the Water Replenishment District of Southern California, the big agency that manages the Central and West Basins under LA County. That statute has a provision written in 1966 which says United Water must set rates so that municipal and industrial users of groundwater pay at least 3 and no more than 5 times what farmers pay. This is a legislative favor for ag, and in my view requires a subsidy of ag by everybody else. And whether a subsidy of ag by everybody else is good social policy or not is not my object. Those of us who like green belts might think it's a good idea. But what Prop 218 says is you can't charge a fee that's not proportionate to cost of service. What Prop 26 says is you can't charge a fee that doesn't bear a fair or reasonable relationship to the benefits or burdens the payer puts on the system. So unless United Water can show that somehow its cost data are such that cities are magically in that window of 3 to 5 times more expensive to serve than ag, they've got a problem. Either their statute's unconstitutional, my view, or their statute's constitutional and they have no fee-making authority except in those rare circumstances when they can prove their costs fall in that window. I won this case in the trial court. We got $1.3 million in refunds to Ventura and $300,000 in attorney's fees. Went to the Court of Appeal and lost in what I considered to be a somewhat unreasonable decision. I usually feel that way when I lose. And I got the Supreme Court to take the case. I got a pre-notice of argument. The Supreme Court now has a practice under the influence of the new Jerry Brown appointees of sending out a notice that says, we're going to put you on calendar in the next 2 or 3 months. Speak now about any hearing date conflicts or forever hold your peace. So that tells me, and since that came out after the April calendar was posted, and because I'm not on the early May calendar, that means I'm likely to be on the late May calendar or the June calendar, because there are no July and August calendars. The court doesn't hear argument in the summer. So we're going to have argument in this case sometime soon, which means we'll also have a decision 90 days after argument by late summer. So what's at issue in this case? First is, are groundwater replenishment charges subject to Prop 218 when, as is universally the case, even in the LA Basin, who'da thunk, there are some people using groundwater for domestic purposes. If there's any domestic customer using groundwater for domestic purposes, they're, under the case law, analogous to an urban customer taking water through a pipe. And since urban customer rates are subject to 218, rural customer rates should be, and therefore 218 provides the rule of decision. That's my case. What the district says is the city of Ventura is not using water for residential purposes. It's a utility. It's using it on a wholesale basis. We should be able to regulate them. This should be a 62 fee, a 26 fee. My response is, okay, if you win that issue, I still think you lose because you can't prove a fair or reasonable relationship, much less proportionality. They do a lot of hand waving and say, yes, we can. This is not to say that agencies can't comply with 218 and 26 in my view, and distinguish agricultural water use from urban water use. You can. There are differences. I just don't think they add up to 3 to 1 to 5 to 1 conveniently, because that's the number that was picked in 1966. For example, agricultural water use recharges the groundwater basin to a substantial extent. So do cities to the extent that we're irrigating grass. So do cities to the extent that farmers are growing, people are have backyard gardens. So you can account for recirculation value. You just have to do it in an intellectually honest way with some data. And don't overlook the tile drains that farmers use to, quote, drain the swamp in order to make land agriculturally useful. So you can make distinctions, and we probably can have some benefit for ag, but it's got to be justified. This case is important because it's going to tell us whether 218 applies in this context or whether 26 does, and it's going to shed light on how we do our cost accounting, what we can cover and what we cannot. The last case I have teed up this year, and I don't have a pre-notice in this one, so this will be argued no sooner than September, and might not be argued this year, although it's likely to be. It's called Citizens for Fair REU, Reading Electric Utility Rates versus Reading. Reading, like every publicly owned power utility, takes money out of the power utility into the general fund on one theory or another. This one's called a payment in lieu of taxes. If there were a private utility in Reading, the city would get tax money to pay for streets and cops and firefighters, and just because they've chosen to municipalize a utility doesn't mean they should give up that funding stream. I won in the trial court on the ground that Prop 26 is not retroactive, and this fee predated 26. I lost in the Court of Appeal before a panel made up entirely of junior justices appointed by Governor Schwarzenegger, all of whom had been in state service before they went on the bench. And those of you in state service have this notion that the budget is its own reality, and when the budget expires, authority goes away. Reading adopts its fee every 2 years on a biannual budget, and so the court concluded it went away when the budget did and you couldn't re-legislate. That's not actually the law. What the law says is when the legislature routinely takes an action and keeps doing it, each reiteration is not a new legislation. It's a continuation of earlier legislation. And that's technically the law, and there's a government code section that says it. It was lost on this Court of Appeal, might not be lost on the Supreme Court. We'll see. This is of relevance because it tells us what the grandfathering component of Prop 26 is. How robust is it? Do we keep our older revenue legislation forever or only until the next rate making? And that will be important to local government, probably less important when you're looking for new revenues for new programs. Here's a case I'm cautious to speak to about this group because there's probably somebody in this room who knows more about it than me, but this is the California Building Industry Association versus the State Water Resources Control Board. It's fully pending and awaiting argument, fully briefed and awaiting argument in the Supreme Court, likely to be argued sometime in the next year. It's a Prop 13 Sinclair Paint challenge to water board fees for water quality programs. The Court of Appeal found it sufficient for the state board to demonstrate that its fees did not exceed the cost of services collecting 8 programs in a bucket. The BIA said your general stormwater permit for construction is its own program and needs to be cost justified separately. The Supreme Court will tell us within the year, I think, how closely the relationship between revenues to programs to costs must be. Other cases that are just decided and are likely to see petitions for review are the California Chamber versus State Air Resources Board case, which came down on April the 4th when I was arguing Jax. And it held that the AB 32 greenhouse gas auction fees aren't taxes because they're not imposed, because you don't have to participate in the auction if you don't want to. That was a 2-to-1 decision of the Court of Appeal with Justice Hull, a Pete Wilson appointee, voting no. Generally, when you have a dissent, that makes Supreme Court review more likely. The Morningstar and Pacific Legal Foundation have made it clear they do intend to bring a petition for review. Stay tuned. Manteca Unified School District versus the Reclamation District number 17 is a case that also came down that same week, in which the 3rd District said that although there's a statute which says that school districts and those who own roads, states, counties, cities, don't have to pay reclamation district fee assessments to maintain levees in the delta, that statute is given no force by a provision of Prop 218, which says you can't exempt government property from assessment without clear and convincing proof that that government property receives no benefit from the assessment program. Now, I would argue that what that means is that we have to account for benefit to government property and find another way to pay for it, and that it doesn't mean we can assess government property because 218 says this creates no new revenue authority. However, I don't have a black dress and a wooden hammer, and 3 people who do said it preempts, and therefore the school district in Manteca has to pay the reclamation district to maintain the levee down there. There's going to be a petition for review in this case, I'm pretty confident. It's also a pretty good candidate for review because it's an important question. So as you can see, we're still litigating what Prop 13 means. Prop 13 passed when I was in high school, and we're still arguing 2 generations later what it means. We're still arguing what 1996's Prop 218 means, and we're just beginning to argue what 2010's Prop 26 means. Wrapping this all up and coming back more concretely to your stormwater question, absent voter support or property owner support for a tax or property-related fee, the best means to fund NPDES mandates and other stormwater recapture may be an array of sources. No one source is going to do it. You're going to have to get niche revenues from many sources. Water and sewer fees may contribute. Trash fees conceivably, because if you use automated trash collection, you produce litter, which ends up in catch basins, and you got to get it out of the catch basins, and therefore some of the cost of your catch basement cleaning program can be ascribed to the trash service. Development impact fees, we can make development pay the cost of the water quality implications of what they do. Command and control regulation in lieu of a fee. What's behind this rather dense phrase? The AB 32 greenhouse gas case said, Morningstar Farms tomato processing plant does not have to pay for greenhouse gas emission. They can go out of business. They can scale down their business. They can treat their own effluent. They can put carbon scrubbers, conceivably, on their smokestacks. They choose to buy their way around the mandate, and therefore the fee is voluntary. Our friends on the libertarian right of this discussion really don't like the AB 32 decision because they don't like the implications that we can sort of order you to do expensive stuff and then sell you a cheaper solution and fund government along the way. I would be skeptical of the survival of this theory were I arguing it to the Supreme Court of 6 years ago. And I had the pleasure of talking to Justice Kennard about government revenues on more than one occasion. But we're not arguing to the Supreme Court of 6 years ago, and we probably won't even be arguing to the Supreme Court of today. In fact, we certainly won't, because Justice Werdegar is leaving in August. And Jerry Brown, reprise edition, will have 4 of the 7 justices that he's appointed. And he's appointed folks with a radically different perspective than Pete Wilson and Governor Deukmejian. So we shall see. And the last is constitutional amendment. There was serious discussion last year among local governments and the environmental community about proposing an amendment to Prop 218 to address 3 issues: the environmental stormwater issue, the tiered rates for water conservation issue, and a third point in last year's proposal was lifeline rates for low-income residents. There are millions of Californians who don't have a safe and reliable water supply. If you live in Maywood, in the industrial rust belt of LA County, you can't launder your sheets at home because there's so much manganese delivered in the water that your sheets will come out rust-colored. And there are millions of Californians who live this way. They're mostly Latinos. And Latino Democrats are the plurality of the legislative caucuses, and they care about this issue. So those 3 were a package. There was some drafting done, there was some polling done, and there was a conclusion that we couldn't sell it in the 2016 environment. So there's still thought being given, but it's very hard to persuade voters to give up the right to vote. And with that, we're ready for questions. And webcast folks should be emailing their questions to storms@waterboards.ca.gov. Those of you in the room don't have to send me an email. You can just raise your hand, and we'll send somebody Oprah-like with a mic to let you speak. We got a question here.
Michael, given that one of the main drivers here is federal law for stormwater, is there anything on that front that could preempt the state law issues and somehow impose some revenue stream? I know it can impose the requirement to spend money, but is there any angle there that might provide a workaround state law to raise money?
Not in a useful way. And the reason I say that is there's a case called Ventura Group Ventures versus the Ventura Harbor District, in which the Ventura Harbor District lost a judgment in federal court that was a very big number. And when the judgment creditor, the person who won the verdict, tried to enforce, they ran into the fact that the Harbor District had no revenue authority. And so they tried to persuade a federal court that California's actually a state court, that Prop 218 was preempted and that they should be allowed to exercise the pre-Prop 13 property tax power of the district in order to satisfy their federal judgment. And the Court of Appeals said, we don't think so. Now, if a California government program were run in such a federally defective way that a federal court were willing to establish a federal judicial receivership, like our state prison healthcare system was in a federal receivership for a long time, conceivably that federal receiver could use federal authority to raise the money necessary to maintain a federally constitutional local government delivery system. But think about how brave a judge that would be. Yes, they have life tenure, but they do have to go to the supermarkets here. My sense is that's an extraordinary, unlikely event that's going to have to require somebody to be grossly polluting an essential resource. Let me tell you another story that is in the neighborhood of your question. There's a package treatment plant serving a 50-lot subdivision in Yuba County on the Nevada County border that is a bad land use decision that never should have been made. And sure enough, you've got 50 working class people who collectively own a publicly owned treatment works, and they can't sustain enough money to hire competent people to run their plant, and their plant fails, and it's putting effluent, shall we call it, into the environment untreated. The federal government sued under the Clean Water Act and won, of course. And then what? Does the federal government now own this little package plant that's dying on the border of Yuba and Nevada counties? The federal government used other tools in their arsenal to twist the arm of Yuba County to step in and take over the plant and run it lawfully. So there are some ways that the big arm of the federal government can solve really egregious problems, but the $8 billion cost of cleaning up the effluent from LA County, probably not. I threw out that $8 billion number. I don't know what it is. I just know it's big and it starts with a B. Yes, ma'am.
I have two questions. The first one is you have expressed some optimism about the ability of local governments to use wastewater rates as security for water systems. And so does this mean that you would be willing to, you also mentioned the willingness of creditors to buy debt. So does this mean that you would be willing to sign a legal opinion for a city that wished to pledge sewer rates for a drinking water loan, that was a good use?
If they're taking water molecules out of the wastewater system and putting them in the potable system, absolutely, I would sign that opinion.
And the second question is, you mentioned rate consultants.
Mm-hmm.
Do you have an opinion about how to find a good rate consultant, or what constitutes a good rate consultant?
There are many good rate consultants. There are some not so good rate consultants. And I'm happy to provide recommendations when I'm not using state resources. Generally, what I would say is the folks who are leaders in their profession, who regularly make rates and have had their rates sustained in court, are good candidates. Those folks who have had their rates knocked down in court regularly are not good candidates. But I can certainly, when I get asked as a city attorney and as a rate-making lawyer, do you have a recommendation? The answer is always yes, and I always give people 2 or 3 names because I think that's just prudent. And I have many fine folks out there, and there's some folks that I will quietly steer you away from. Up here, actually, you're probably next. Yes, ma'am.
Okay, I think I have 2 questions. To continue on to her question, you said if a wastewater utility takes a molecule of water and puts it into a water supply, then yes, they can use those fees. Does that apply to recycled water? And does that apply to the future flange-to-flange potential direct potable use? And lastly, does that also apply to that molecule of water being discharged into a surface water and then pulled out downstream for a water system?
The answer to all those questions is yes. If what you are doing is creating a water supply for any human use, whether it's a recycled supply for irrigation and non-potable use or a potable supply, you can recover all the costs of water supply, including those costs which would normally have been paid for by the wastewater utility when it used to just dump the treated water into the environment.
Okay, so if most of our surface waters in California have the beneficial use of Mune, then why would that not be widespread?
You said they have the beneficial use of, and used a word I didn't capture.
I'm sorry, they have the beneficial use in the regional board basin plans for municipal supply, which is for municipal supply.
Sure.
So would there be a blanket acceptance of use of those fees, or is it really municipality specific?
It's legally possible. It is politically fraught because you're getting multiple agencies to cooperate, you're getting multiple agencies to share legal risk, because although it's my opinion that the law allows this, and the legislature thinks so too, Howard Jarvis probably doesn't agree, and they can find their way to the courthouse. And there's perceived political risk as well. And cooperation that involves other people's money is always fraught. So it's legally possible, politically fraught.
Okay, one last quick question, which is the basic question. What's the difference between a fee and a tax? What difference impacts this whole stormwater issue with financing?
The primary difference that matters is taxes require voter approval, and taxes that are restricted to a particular use, which is what you want to restrict it to this use, require 2/3 voter approval, and therefore are politically impractical in most political environments. Fees either require nobody, mother may I, or they require mother may I from property owners and registered voters that might be attainable, particularly if there's a sense that somebody else is going to pay the fee. It's easy to persuade people to tax other people. Don't tax me, don't tax thee, tax the guy behind the tree. I think that was a senator from Louisiana. Fred probably knows who that quote's from. Senator DeLong, yes. Your mic is not working.
You mentioned?
Closer to your mouth, I think.
And the standards.
Or why don't you go ahead and ask it and I'll restate it while we figure out the mic situation.
Okay.
There you go.
You mentioned about 218 and the amount of analysis that needs to be done in order to make these work, and they tend to be on a jurisdictional basis, a city, sanitary district. But the state has been in a movement over a number of years to try to get water resource management done on a watershed scale through the IRWMs and now through SGMA. And so how do we think about conforming all of those rules that tend to apply to a given entity to a resource management process that wants to get stormwater captured, treated, used on a watershed scale that might involve 3 cities, a county, 2 water districts, and a couple of sanitary districts? How does that group, through an IRWM and through the SGMA process, how are they able to set up a fee structure that will make sure that water that starts at the top of the watershed flows to the bottom where the cities are and can be used then in the water system? Because in looking at the IRWMs, that they tend to do the planning work and then they forget the financing work. The same problem occurs, I think, with SGMA. So how do we get that 218 working process conformed into the resource management scale of a watershed?
I can think of at least 2 ways to do it. One is to form a joint powers authority among the affected agencies. JPAs can exercise any power that's common to all of the parents, all the parties to the joint powers agreement. So if all of the parents have fee-making authority, you form a JPA, it has their shared fee-making authority, and it imposes a blanket fee. That's one model. A simpler model may be this: have an agency take the lead and have it impose a fee for its cost to provide the whole program. And the fee that it imposes on its customers is 218, must be 218 compliance. The fee it imposes on every other government doesn't have to be 218 compliant because those other governments are not compelled to pay it. And more to the point, 218 does not regulate how government spends money. It regulates how they raise money. So, for example, if the cost of operating a water utility is to pay licensing rates to the Department of Public Health, whatever the Department of Public Health charges, we have to pay, and we're entitled to recover all of that cost from our customers when we do our rate making. So I think either of those methods, a collective JPA approach or a lead agency charging the others approach, should work. The question is, do we need to do anything with 218 in order to get resource basin scale approaches to these fees? I don't think so. I don't think we need legislation. I don't think we need a constitutional amendment. I think we just need cooperation, which may be harder to come by. Further questions from in the room? In the back. Yes, sir.
Michael, you may have just answered this question with the JPA, but if you go back to your slide about conclusions, it seems to me that disparate agencies would have to pass these fees or some sort of process. A trash fee would have to potentially be from a sanitation district, and a development impact fee from a city or a county, and so on, a water agency for the others. How do they typically work together on this, or how does that happen?
The JPAs are common, and local governments rely on them regularly. Sometimes we don't bother with a JPA, we just do an MOU between agencies. So for example, the wastewater that the Navy generates on the southern half of the naval base Coronado actually flows into Imperial Beach. Now we're litigating because the wastewater is now viewed as a resource and Coronado doesn't want to be losing it. But an MOU would have been sufficient to have Coronado say, Imperial Beach bear a portion of our service burden and charge us for it. Remember, all of these rules that I've spent the last hour talking about apply when we impose a revenue measure on society. They don't control how we spend money. So if I've got a water utility and I've got fees to provide water service, if I've got to pay another government in order to lawfully provide water service, I get to spend the money that way. And then when I do my next rate making, I'll take into account what those costs are likely to be.
I guess my point is, you're the water agency. Have you seen scenarios where they not compel because they can't, but they make some sort of a deal with a sanitation district and a city to make this sort of the overall action pencil?
MET's rate for imported water is approaching $2,000 an acre foot. There are 19 million Californians in 6 counties served by hundreds of water agencies who think that's pretty expensive water. And MET is actively subsidizing local resource developments. And every water manager I know, particularly in the midst of the worst drought we've seen in my lifetime, is eyeing greedily the water coming out of the public-owned treatment works. I don't know that these numbers are current, but they were current at one time. California is recycling 1% of its sanitary flows. Israel recycles 19% because Israel has no choice. They're in the red desert. I think we're headed for the red desert, whether that's, and again, I'll use provocative language, whether that's climate change or regulatory drought or different social expectations or whatever it is, we're heading to a world in which water resources are more constrained, and we're going to have to chase out inefficient uses, and we're going to have to find ways to get more efficient use of the resources that we have. I don't think you're going to see publicly owned treatment works flowing to the ocean absent an environmental mandate in 30 years. Did we have any email questions?
Yes, we just had a question come in. Question from Susan Reyes. Do you have an opinion of EPA's financial capability assessment framework? How could MS4 permittees benefit from conducting a financial capability analysis?
I'm not familiar with that particular framework, but what I will tell you is that there is a lot of work being done in local government, some of it led by the League of California Cities. It's partly in response to some spectacular failures of cities like Stockton and San Bernardino and Vallejo, and partly under the really serious pressure of rising PERS rates, to help local governments begin to understand the long-term stresses on their finances and the long-term strategies to manage them. So there's more thought being given than there historically has been to this question of big picture framework of what's your financial state. And the pressure of 218 and 26 has created that pressure in the utility world already. When you do a cost of service analysis, you usually start with a 5-year financial projection, a 5-year capital improvement plan, then you get down to rate making, because you can't set a rate to recover your costs until you have a pretty accurate prediction of what those costs are going to be. So that was a long-winded way of saying no.
I have 2 more here, but these are just comments really. One is from Chris Ewers with Ewers Engineering. The City of Tulare has used this new approach by unifying its water, wastewater, and stormwater systems under a single utility to unify funding. It is in place, though the city has been slow to put the funding pieces in place. Another one from Con Chu from City of Anaheim.
Let me comment on that before you turn on.
Oh.
We've been talking about how collaborations between utilities can allow financial resource sharing. And the primary model we've been talking about is if the water utility benefits, the water utility can pay. If the sewer utility benefits by getting rid of its effluent in a lawful manner, it can pay. So there's an opportunity to slide these costs from one side to the other. Whenever multiple programs share a fiscal structure, there's a reasonable, within the range of reason, we can allocate costs. How much flexibility we have to allocate costs will come to us in that case of the BIA versus the State Water Resources Control Board. But consider this, Santa Monica arranges their utility flow so the dry weather flows in their storm sewer system flow to their publicly owned treatment works and are treated before they flow to the environment. That same treatment works serves the sanitary flows from the community of Santa Monica. But it's one building with one staff and one capital plant. And the city gets to allocate its costs reasonably among the beneficiaries, one of which has a funding source that's reliable and bondable, and one of which doesn't. And I will leave it there. Next question. We got a live question. Yes, sir.
Yeah. You mentioned Senate Bill 231, Hertzberg's bill. Given that you work for a lot of municipalities, how would you advise your clients who want to use that bill if it were to pass? How would you advise them the ways of using it?
Personally, I would advise them not to rely on that bill, but just to do a well-documented and legally reviewed cost of service analysis which demonstrates benefit to utility X from services from utility Y. Just say, this is our business model. We supply water by getting it from the publicly owned treatment works. We supply water by getting it from a briny basin. We supply water by getting it from an ag drain. This is our water supply. We treat it, we clean it, we use it. I would just do it through an intellectually honest, carefully reviewed cost of service analysis, and I wouldn't bother. And I appreciate what Senator Hertzberg is trying to do. I think he will have a beneficial impact on the world. But legally, I don't see the need to go down that path. I think I can get there using existing tools. I think we had another question.
Yeah, I have a question. We have a combined wastewater and storm drainage system. Is it possible for us to finance the drainage part of that completely with our wastewater rate revenue?
No.
No. Okay.
Partially, yes. Entirely, no. How far you can shift those burdens is within a range of reason. And exactly how exacting the court's review of those judgments are going to be, we should find out more in the BIA case. More questions from within the room before I think we had, yes, we got one here. You're looking for green lights.
I think I have a green light.
There you go.
How do you think Wall Street will react to, I don't know how to characterize it, overlapping revenue pledges?
Wall Street is in the business of making money. They know that people pay their water bills and pay their sewer bills, rain or shine, good economy or bad economy. So revenue bonds backed by utility bills are eagerly sought. They have a low credit risk and a low cost of money. Introducing any uncertainty creates risk, creates transaction costs, and either discourages lending or raises its cost. So initially there may be some uncertainty, but not if we pursue the tactic I discussed with Sean. If we're just doing a straight cost of service analysis, we're just using water molecules that started on that side of the street, I don't see much complexity, uncertainty, or risk. On the other hand, easy for me to say, I'm just the city attorney, not the bond lawyer. There may be other folks in the audience who have more expertise in the finance industry who want to comment. And if so, I'm sure the mic will find its way to them. I did have you in mind.
Since we're all friends here. Yeah, I think you're right. I mean, it's all fact determined. If you have multiple credits and they're severally responsible for a portion of the bill, the rating tends to devolve to the lowest rated participants. So there may be ways in which you want to mitigate that. You might do it with bond insurance. You might do it with some kind of step-up agreements that fit within the lines of reasonable cost. But you might do passive validation, meaning you wait 60 days after the adoption of the the indenture before you sell bonds, so that the ability to challenge is minimized. But I think borrowing money is always the easy part. Paying it back is the hard part. If you can find a way to pay it back, you can probably find a way to borrow.
Howard Jarvis tried to take a run at validation and got a bill introduced by a Republican assemblyman, and the bill was withdrawn within days. Because basically everybody in the credit industry said, if California passes that law, you will no longer have access to the credit markets, which I think is true. And at least the legislature believed it. Any more questions in the room before we check our emails? How are we doing on the email front?
No new questions coming in. There's just one more comment, which I'll read. This is from Con Chu. He's with the City of Anaheim. Just recognizing the need. Please provide us some good rate consultant contact information. If you have someone in Southern California, it's much better. I think this just really kind of just speaks to the need.
Contact me offline, and there's a good firm in Pasadena.
Okay, there you go. I was going to put my own plug-in here that we at the State Water Board have recently been in contact with the California Stormwater Quality Association. We're planning on trying to develop a website that will try to capture some of this stormwater funding needs and be dedicated to that. So these are the kind of topics that we might try to incorporate as part of that resource.
Another question here in the audience.
You said that Prop 218 governs how governments raise money but not spend money. Has there been much litigation on the requirement that the revenues raised go pay a reasonable cost of service? Has that reasonable qualifier been litigated, especially with respect to ideas for developing water supplies that could be more expensive, but that might also address stormwater pollution and so forth?
It's not quite accurate to say, if I did say, that 218 doesn't control how we spend it. We have to spend it for the service for which we've imposed the fee, and we have to cover reasonable costs. Courts are not well equipped to draw lines. Line drawing on a spectrum where any place you choose is going to be arbitrary at the margin is a legislative exercise. So courts are not very well equipped to make fine judgments. Generally, what courts will do is rigorously review your process and review intellectually your justification, but they'll accept the case framed the way you framed it. So I lost the San Juan Capistrano case because I framed it as tiered water rates making more heavier uses of water cheaper, more expensive than cheaper uses based on the costs of our sources. And I did that because the rate-making consultant wrote me a report that said that's how she'd structured the rates. And I didn't learn until the amicus brief showed up in the Court of Appeal that she'd fudged the math, and that there just was no relationship between how much water we were selling at a given price and how much water we had available at that price. And so Justice Bedsworth did what you would expect a judge to do under those circumstances and ruled against me. There is much litigation about what costs can be ascribed to a fee. The BIA versus regional board, state board case is one. There is much argument in my Ventura case about whether the water rates charged to the city of Ventura can be used for such things as running the recreation concession at the lake. One argument is that you can't have a lake without a FERC permit, and you can't have a FERC permit without a recreational component, and therefore renting boats to kids at the lake is part of the cost of operating a water utility. The other option is to say, no, you've got a concession agreement and you're making money, and therefore you don't need a subvention from our water rates, and you shouldn't be allowed to. So absolutely these questions get litigated, but courts are not really well equipped to police every detail. They're going to stay thematic, I think. Other questions?
I was going to ask my own question.
Please.
Going back to the developer impact fees, have communities been successful in packaging operation and maintenance costs as part of that?
In a word, no. In order to a development impact fee under the federal constitution, we have to show the exaction from the developer is roughly proportionate in extent to the burden the developer is imposing on society and logically related to the burden we're trying to mitigate. So when the Coastal Commission said, you want to build a house that's going to obscure views of the ocean, so give us a path to the ocean across your property, the U.S. Supreme Court said no logical nexus between visual access and physical access. In a case in which a suburb of Portland wanted to fund a pathway along their creek, they said, if you want a permit to expand your hardware store, you've got to give us a pathway the whole length of your property behind the store in the blackberry bushes to mitigate the pedestrian and bicycle traffic your hardware store is going to generate. I have images of people with lumber on the back of their bicycles. The Supreme Court said there wasn't rough proportionality. So those two requirements of logical nexus and rough proportionality basically mean we get capital costs from development impact fees. We don't get M&O costs. We can get M&O costs from Mello-Roos districts, which impose taxes, and we can get M&O costs from assessments. But generally speaking, you can't get M&O costs from a development impact fee. You can get it from a regulatory fee, you can get it from a service fee, but not a development impact fee. Seems like we may have exhausted your intellectual appetite, which times it may be time to send you off to lunch and indulge a different appetite. Thank you for your attention and your patience. Good to see you, Fred.